Present.
Representative Jello. Representative Filippi. Representative Coughlin. Representative O'Grady.
Here.
Thank you, and welcome to, and Representative Agello has just joined us. Thank you to the, welcome to the first committee on the Judiciary meeting of the year. Today we have 17 bills total, 14 marriage solemnization bills, including 6 by Representative Azanaro. Apparently love is in the air down in Westerly. But I will take a motion by Vice Chair Costa, seconded by Secretary Blazajewski, to bundle those 14 marriage solemnization bills for a vote. And Representative Lally, seconded by Representative Canario. Would you gentlemen like to move passage of those?
I do.
Okay. All in favor? Aye. Any opposition? Okay. Our 14 marriage solemnization bills pass. Vice Chair Costa, would you move to hold all remaining bills for further study?
Yes, sir. Hold all bills for further study.
Seconded by Representative Blazajewski. All in favor? Aye. Is there any opposition? Okay, so let's take some testimony on those 3 bills. Let's begin with my bill, House Bill 5019. This bill I introduced at the request of a constituent, Richard Kite, Esquire, who is here. Mr. Kite, would you like to come up and tell the committee about this bill, please?
For the record, my name is Richard Kite. I'm a resident of 565 Central Street, Mapleville, Rhode Island. As the chair indicated, I reside in District 47. I've received, just by way of background, I inherited a case in October of this year, beginning my 38th year in practice, and it was a case based on wrongful termination of employment. The facts of the case basically briefly outlined are that the employee received a subpoena to testify in a family court proceeding as a third-party witness. She was not a party to the divorce. The employer said, if you go, you're going to be fired, in effect. As I indicated, the reason I inherited the case was a breakdown between she and her prior counsel, and the case was under a deadline to have her deposition taken. That was accomplished, and after the deposition, counsel for the employer indicated, you realize, of course, there is no protection for employees if they're subpoenaed in the court. For the attorneys on the panel, that struck me as something of a surprise. I hadn't had an opportunity to research it because the deposition was more important. I contacted the predecessor counsel, and he indicated that, in fact, his research revealed that there is no statutory protection for people who are subpoenaed in the court. And he brought the case under the theory of a Whistleblowers Act, which is a creative approach, but my further research indicated that there are several other states that do have similar protection. The decision that the quandary that my client faced was, does she go to court and risk termination of employment, or does she, in fact, appear in court after the attorney in this case threatened to have a bench warrant issued against her or request a bench warrant? She appeared in court and she was promptly fired. The bill, I think, would protect employees from making that awful decision. Do I risk termination of employment and all the financial repercussions that come after that? We are still emerging from a difficult economy. Or do I risk sanctions under, in this case, it would be Rule 45 of the Family Court Rules of Procedure, or the Superior Court has similar rules where a judge can sanction the individual for refusing to comply with a subpoena. In addition, this bill, as drafted, would protect, or at least protect, the employees who are in front of other quasi-judicial bodies, investigative bodies, because I think the larger picture in this case is the court system would be, in effect, indirectly hampered. I mean, the employee or the individual would have to make that decision. Do I risk being terminated from employment, or do I risk the possibility of being sanctioned by a court? I think by this bill, if it is enacted, it would protect the employee from having to face that dilemma. The bill isn't so much, or at least I don't think the purpose of the act is so much to enhance lawsuits. It's to make very clear that an employee should not be terminated from employment because they've responding lawfully to a subpoena that was issued by some body, and to cooperate in the judicial process. The experience of some of the attorneys here may be similar to mine, but it's tough enough to get people to go to a court voluntarily. It's tough enough to get people to participate in the judicial process. And I would think an employee would be more inclined to protect his or her own self-interest in keeping the employment rather than to cooperate with the judicial process. So with that, unless there's some questions, I would urge that this committee support this bill and move it out of committee.
Mr. Kite, when we spoke, you had mentioned that Massachusetts does have statutory protection.
Yes,
Is that correct?
yes. My research indicated there's similar language to this, and there are other states that don't come to mind. But again, doing my case-maker research, the number of states do have this kind of protection.
Thank you. Does anyone in the committee have any questions for Mr. Kite? Representative Lally.
Just a couple of remarks. I signed on this bill because 48 states, I believe, have good faith employment. Rhode Island and Texas only have employment at will. So I would think that in other states, good faith employment would probably hold up with this type of subpoena from the courts. But if Massachusetts, which is good faith employment, thought that they had to give the extra sanction, I think for the judicial system to operate efficiently, I think that this is a good bill, and I appreciate it that you brought it to the chairman's attention. Thank you.
You're welcome. Thank you.
Thank you. Any further questions? Thank you, Mr. Kite.
Thank you very much for your time.
Could we hear from Stephen Brown from the ACLU, please?
Thank you, Chairman, members of the committee. My name is Stephen Brown. I'm Executive Director of the ACLU of Rhode Island. I'm here to express our organization's support for this bill. Representative Lally really hit the nail on the head. Because Rhode Island is an at-will employment state, in the absence of specific statutory protections, employers are free to fire employees at will, including in situations as this one addresses, where they are subpoenaed into court. It's absolutely critical that employees know that they don't have to fear that sort of decision, whether to avoid a subpoena in order to keep their job. This is not a unique situation. In fact, it was only last year that the U.S. Supreme Court had to deal with the situation of an individual and government employee being fired, and the court held that the First Amendment protected individuals in those circumstances from being fired. But that doesn't help anybody in the private sector, and that's why a bill like this is so important, and we hope it will be given favorable consideration by the committee. Thank you.
Thank you. Any questions for Mr. Brown? Thank you very much. And that will conclude testimony on House Bill 5019 by myself. And I see a few more members have joined us. Representative Almeida, Representative Filippi, Representative Edwards. Did anyone else not have their votes recorded?
I'd like to be recorded in the affirmative for the solemnization of marriage bills, please, Mr. Chairman.
So ordered. How about the holding of the other three bills?
Affirmative as well, sir.
Okay, very good. Same request. So ordered. Okay. Let us next take up, I know Minority Leader Newberry is here waiting to testify on Representative Edwards' bill 5054, the Joint Committee of the Repeal. Representative Edwards?
Thank you, Chairman, members of the committee. This is the third year I've introduced this piece of legislation, and it is fairly straightforward. This is a bill that came to me out of Kansas, and in Kansas they use the executive department to implement a department of the repealer. What I have proposed here would be a joint committee, Senate and House, composed of equal members, to hear off session, even though it's not spelled out, but that was my intent, to hear off session from the summer and the fall, archaic, old, unconstitutional bills that no longer fit with our overall law structure. If you have, like I do, I have a copy, full volumes of the Rhode Island laws at my house, all the green books. Every year we get a box, fairly large box, with all the additions to the laws. I think this would be a perfect way for us to go through as a legislature and glean out the laws that are no longer needed, laws that are archaic, laws that don't make sense, laws that don't match other laws. And it would make sense to have the legislature do it because we would be the ones researching them. We would look for holes that these bills being pulled out might create. So, again, this is a fairly straightforward bill. I think it's a great piece of legislation, and I urge passage.
Thank you, Whip Edwards. Minority Leader Newberry.
Thank you, Mr. Chairman. Just very briefly, I've co-sponsored this legislation with Rep. Edwards the last 3 years, and the only reason I'm here today is just give you a concrete example that just came up of how this legislation might come to use. About a month ago, I directed the House minority staff to look for ways to save money in the state budget as part of the budgetary process. And one of our staff members was combing through the Medicaid statutes, and he found an entire section of Medicaid law. He was trying to figure out what it did, and so he contacted the House Fiscal Office upstairs and was told the entire section is irrelevant, it's redundant, and it no longer is in effect. But it's still part of the general laws. I don't know why. It may have something to do with the Medicaid waiver from 2009. But the bottom line is there's an entire section of the law dealing with Medicaid that doesn't need to be there. I'm sure that's not the only example of the kind of thing where this statute could come into play. But if we want to, make government more efficient, streamline the laws and so forth, I think this is an excellent idea. So I would urge passage at the proper time. Thank you.
Thank you, Leader. Any questions? Thank you. Could we hear from Stephen Brown from the ACLU, please?
This is not just an academic exercise in repealing laws. This past year, we had to go into court to represent a person who was to challenge a law after a person was unlawfully arrested under a state statute that had been on the books for ages, that the U.S. Supreme Court had declared unconstitutional, another state's virtually identical statute unconstitutional 2 decades earlier, but because the law was still on the books, a municipality continued to enforce it, leading, as I said, to the arrest of an individual. We got the law struck down. It cost the state money. I think having a commission like this take these laws off the books would be very helpful in the short term and the long term. Thank you.
Thank you. Any questions for Mr. Brown? Representative Agello.
Thank you, Chairman Keeble. It seems like other states must be in similar situations. I find it hard to believe that only Kansas is doing something about this.
I really don't know what's going on in other states.
Okay. Thank you. Yeah.
Any further questions? Thank you very much, Mr. Brown. And from the Rhode Island Tea Party, Michael Pugnana has signed up in favor of this bill without oral testimony this evening. And so that will conclude testimony on Representative Edwards' bill, House Bill 5054. And we will next take up another one of Representative Edwards' bills, House Bill 5051. Whip Edwards.
This bill bill I brought in last year. I brought this bill because when we had this kind of a bridge toll put in effect, one of the biggest pieces of equipment they put on the bridge was a gantry loaded with cameras. And I was shocked at how many cameras the Turnpike and Bridge Authority actually operates. They have them on the Newport Bridge, they still maintain them on the Seconic, and I believe they're adding them to the other bridges that they own. This is just one small part of Rhode Island government that has cameras. What they're doing with this information was what I wanted to know, and the Turnpike and Bridge Authority told me they have an internal policy about how they handle the footage and images that are captured on their cameras. Regimes can change, directors can change, things could happen, an internal policy could quickly disappear, and you could have wholesale release of any images coming across the state's cameras. The taxpayers of the state of Rhode Island are paying for these cameras. We're paying for their maintenance. We're paying for their use. We're paying to maintain them. The state of Rhode Island should be the only ones able to use or acquire any of the images. There's a very clear exception in here for law enforcement. If law enforcement needs to use the cameras in any way, they will have full and complete access to them. This is meant to prohibit private use of any type of these cameras, which we are all paying for. Again, fairly straightforward piece of legislation, and I'd be open to any questions, Chairman.
Thank you. Any questions for Whip Edwards? Thank you very much.
Thank you, Chairman, members of the committee.
Could we hear Todd Sandall, please?
Good evening, Mr. Chairman, members of the committee. My name is Todd Sandall. Thank you for the opportunity to speak on this bill. I agree. I think it's an excellent piece of legislation. It does a lot to secure individual liberty rights, individual privacy rights. I do have a couple concerns about some things that are missing from it, though. On page 2, line 13, section E, it states, any person violating the provisions of this section shall be guilty of a misdemeanor. Nowhere else in this piece of legislation does it talk about the person so much as the body of government, the organization of the government of the state of Rhode Island. I would suggest maybe a sub-A would be appropriate that has language to the effect that any person who either directs or performs an activity which is contrary to the provisions of this section shall be guilty of a misdemeanor. That only makes it onto a personal level of an offender instead of, you can't charge a government with a misdemeanor. And then the second comment I'd like to make is it says that they would be guilty of a misdemeanor, but it doesn't say what the ramifications are of that. There is no penalty associated with it. It sort of takes the teeth out of this law. I think other than that, it is an excellent piece of legislation, and I would encourage you to approve it with some minor changes like those. That's really all I have. Thank you.
Thank you. Any questions? Thank you very much, Todd. Could we hear from Michael Pugnana from the Rhode Island Tea Party, please? Another constituent of District 47. It's Burrillville now.
That's right.
Welcome, Michael.
You are my representative, Chairman Cable. I thank you. And I'm here to talk about this excellent piece of legislation. Can you hear me? Yeah. Rep. Edwards, you are on a roll today with all your good legislation. I'm going to speak very briefly to the fundamental nature of what the Fourth Amendment and Article 1, Section 6 really say. They're designed to put very strong and clear restraints upon the government for its ability to conduct searches and seizures of the individuals that make up our society. I think this speaks directly to that need to place limitations. We've all seen the enormous explosion of technology that allows immense levels of surveillance to the point where you never know if you've got a drone flying around your house. We all remember the experience that Representative Tanzi dealt with a year or two ago, which was really an eye-opener. We all are subject to that, regardless of where we come from or what political beliefs we have or what our standing in life is. And we need to have these very clear and very strongly defined restraints upon our government for what it can actually do. I think this bill speaks directly to the need for that. It's something that we have to be very proactive in making sure that the rights of the individuals who make up our society are held as absolutely supreme and sacred, and nothing else, including a desire for better security or public safety, can be allowed to stand in the way of protecting those fundamental rights. And I applaud Representative Edwards and Representative Philippi, Representative Roberts, Representative Abney, and I hope I didn't leave anybody out, for stepping up on this. And we support, the Rhode Island Tea Party supports this legislation. Thank you.
Thank you, Mr. Pugnana. Any questions? Thank you very much. I'm sorry, Representative O'Grady. Sure.
So in looking at this bill again, I noticed that it speaks specifically to the state or subdivisions of the state, but does it apply to vendors? So I believe, and correct me if I'm wrong, that the Easy Pass system has some sort of vendor operating behind the scenes that might have access to this data as well. Are they prevented and penalized for using that data incorrectly?
The cameras that the Turnpike and Bridge Authority owns are directly monitored by them. They use it's a security issue, from what I understand, because their bridges and their large spans, they have direct control over them. Easy Pass has it for the license plates only, and they have access to it. So the vendor would not be the one in direct control of the cameras.
Yeah, well, that's comforting to hear. Thank you.
Thank you. Any further questions? Representative Agello.
That brings up the issue of red light cameras that we have in Providence, which are taking images of cars, and as a political subdivision of the state, those are monitored by a private vendor with Providence Police, I believe. It looks like they would be taken into effect with this legislation. Is that your intention, Representative Edwards?
Yes, it is.
Thank you.
Thank you. Any further questions? Thank you very much. Can we hear from Stephen Brown from the ACLU, please?
Thank you again. The ACLU also believes that this bill is a very important step in trying to address privacy rights in the technological age. We would recommend some amendments as well, though, to strengthen and promote its goal. I'll just give two examples. You've heard the discussion of having the penalty be a misdemeanor. We strongly believe that the penalty should be civil in nature in order to make sure that it really is effectively used. We expect it would be very rare for criminal penalties to be brought against individuals working for the political subdivisions of the state who engage in this activity. Civil remedies, injunctive relief, and damages, I think, would be much more effective. We also think it would be important to address some of the points that actually Representative Edwards made in explaining the bill. There are no standards for those situations where, for example, the Bridge and Turnpike Authority does collect data. There are no limits on how long the information can be kept. We would encourage having some standards in there in order to protect the privacy of this information in those circumstances where the information is being collected. But as I said, on the whole, we think this is a very important step in protecting privacy, and we hope some version of this will pass. Thank you.
Thank you. Any questions for Mr. Brown? Thank you very much. And that concludes testimony on House Bill 5051. And that is our final bill for the evening. The committee does have some new members this year. We have Joe Solomon from Warwick and Blake Filippi from Richmond, Charlestown, Block Island. Any other part of the state you represent, Representative Filippi?
All of Block Island, Charlestown, and portions of South Kingstown and Westerly, and unfortunately none of Richmond.
That's quite some, okay, that's quite some district. Welcome to the committee. And a veteran of the General Assembly, Jay O'Grady, also in his third term, from Lincoln, Chairman's Choice. Welcome to the committee, O'Grady. So with that, the two new members, Representative Solomon moves that we adjourn. That's seconded by Representative Filippi. All in favor? And we are adjourned.